Good evening. This is Rahul Reddy. We're live here from Houston, Texas, every Tuesday from 5 p.m. Central Time to 6 p.m. Central Time. We do bring in immigration updates. We do take live questions for 1 hour, and we do answer the questions. Along with me is my business partner, Emily Neumann. What do we have today, Emily?
Yeah, today we want to talk about for people who have a 2 H-1B household, where the husband and wife are both here in the U.S. on H-1B. What is the process for one spouse to convert to H-4 EAD based on their spouse's I-140 approval? And then how do they convert back to H-1B, especially in the situation where the reason you're making the switch is maybe a 6-year limit issue and you're waiting for your labor to be approved? Once you get that I-140 approved while you're on H-4 EAD, which is an option, how do you get back to H-1B? Do you have to go through the lottery again? Do you have to go outside the country? So we'll answer all of those questions. And then
yeah, go ahead. Sorry. Go ahead.
We'll also talk about the situation where people have multiple I-140 approvals, one in EB2, one in EB3, both have the same priority date, usually because they did the downgrade sometime in 2020. And so your 45 is pending, you filed it with the EB3 downgrade maybe, and then later EB2 moved ahead. So you did the transfer of underlying basis to EB2, and now maybe EB3 is ahead. You've submitted all these different requests, but what line are you actually in? How do you know if you are being processed in EB2 or EB3, and how do you get them to switch you to the other line that might be better right now? Another question that we get is, can company B file a PERM labor certification or I-140 for you while you are working for company A? Is there any requirement that you be working for the company that's actually sponsoring you for the green card during the process? And lastly, a common question we get is, I'm in the US, I've got my H-1B status, and my visa is going to expire. What do I need to do? And then we ask, okay, well, did you file an H-1B extension? Do you have the I-94 extended? And then we talk about the difference between the I-94 extension and the visa, and when do you actually need a new visa? Because in many situations, if you're staying in the US, the visa can expire without impacting your status. So going back to the top there, H-1B, H-4 EAD, back to H-1B, what are all the steps involved there?
There's a lot of misconceptions. I do a lot of consultations. Of course, everybody knows that we do have a daily Zoom calls. People come in. There's a lot of misconceptions that, hey, once you move to H-4, you cannot come back to H-1B without going to the lottery system. That is a lie. That is a lie. You can come back. Once you're counted toward the H-1B number, you don't need to be counted again for the H-1B number for the next 90 years. Why not 91 years? I don't expect you to live that long. Now, a lot of people hesitate to moving to H-4 plus EAD. They wait until the last moment to move to the H-4 EAD. Let's say, for example, the husband has an I-140 approval H-1B, and the spouse, the wife has the H-1B, it is expiring in 6 years, and it's expiring in, let's say, December of 2024, the 6 years, and the PERM is not getting processed. They wait until September to call us and ask, when can I move to H-4 EAD? They should have moved the H-4 EAD a long time ago. They think that once you move to H-4 EAD, you cannot come back to H-1B. That is a lie. There is another misconception that once you are on H-4 EAD, you can't file the labor and I-140 approval. Is that true, Emily? Let's say, for example, I'm working for Deloitte and I move to H-4 EAD and I'm still working for the Deloitte. Can Deloitte still file the I-140 labor and I-140 for me in H-4 EAD?
Yes, absolutely. You don't have to be only in H-1B status in order to be processed for a labor certification or I-140. The process can be done while you're in H-4 EAD.
Can I get to the 7th year H-1B extension even though now I'm in H-4? Let's say I've used up 5 years and 364 days of H-1B. Now I'm in H-4 EAD right now. I got I-140 approval. Can I get a 3-year H-1B approval?
Yeah, you can switch back to H-1B without going through the lottery. As a change of status, you don't need to leave the country to do it. You can file it any time of year. And with the I-140 approval, assuming your priority date is not current, you can get a 3-year H-1B and keep renewing every 3 years. Even if you're not with that company anymore, you can do it to move to other companies as well.
So the concept that I have to be in H-1B to extend beyond 6 years of H-1B once I-140 approval is a lie, according to you. The concept that I have to be only in H-1B to file a labor and I-140 approval is a lie. The concept that once I move to H-4, I cannot come back to H-1B is a lie. Is that right, Emily?
Correct.
Okay. Can we go to the next question, Emily?
All right. Yeah, go ahead.
The EB2 and EB3 guys, recently we found out sometimes, practice makes perfect. So when we filed a lawsuit against USCIS, hey, my client's 485 is not getting approved under EB3 when the priority date is current. What this guy did was that in 2020, they filed the 485 under EB3 downgraded, as people already know that at that point of time in October 2020, the EB3 was current, EB2 was not current. And then what happened is that, as Los Angeles highways, which lane moves faster, we don't know. Now EB2 moves forward. This guy filed an I-485J supplement and moved to a different company. I-485J supplement to request an EB2. And he now is and the 485J has been filed in EB2 and I-485 has not been approved. When we sued the USA, hey, my client's green card is not getting approved. They said, hey, you filed the I-485J supplement under EB2. Yeah, but that's not approved. Yeah, but you've requested for EB2, he's an EB2. What we request is that if we don't know what category you are, we don't know whether you're EB2, whether we don't know whether you're EB3. What we tell you one thing is that if the date becomes current, you are on that category. You have to act, you are on that category. And if needed though, you need to file an I-485J supplement to activate your file to tell the USCIS, look, I have an EB3, I have an EB3 I-140 approval. The concept that also comes is that, do you need to be working for the company that has an EB2 or EB3 I-140 approval to file I-485J with that? No, you don't have to be. Let's say you have an I-140 approval with company A in EB2 and EB3. Now you move to company B. Company B can file an I-485J requesting that on the I-485J. It is the underlying basis is the I-140 and you can put EB2 or EB3, whichever date is current. So I want you to consider this very seriously. If the date is current, you need to request the USCIS to adjudicate the application under that particular category though. What we normally say is that, even mom doesn't feed the baby if the baby doesn't cry. So here we need to cry and we need to mention that you are in that particular category, whether it's the EB2 or EB3, whichever is current, to request yourself in getting adjudicated in EB in your 485 applications when the dates are current.
Yeah, and it's really important to act quickly, be the first one to get in when your date becomes current again. Don't wait around for 30, 60 days, giving USCIS a chance to get around to processing your case because your case is just sitting there. No one's looking at it. If you have that case remains pending status and your date becomes current, you need to submit a supplement J as quickly as possible to get the case moving.
Emily, this become a little bit issue on this. Can company B, I have a couple of series of questions on this though for you. I'm working for company A. Company A is not filing the labor certification application. Can I approach company B and they're willing to hire me once I get the green card? Can they file the PERM labor certification even though I'm not working for the company?
Yes, absolutely. The entire green card process is always based on the future permanent job that you'll take when you get your green card. It does not require current employment.
Is it mandatory that I have to be on the payroll of the company to file an I-140 application with company B?
No, it's not mandatory. Some companies might make it a company policy, but from an immigration standpoint, it's not mandatory. However, there's an issue that can come up with the I-140 if you're not working for the company, and that's regarding the ability to pay. So every company that's filing an I-140 petition has to be able to prove that they have the ability to pay the salary that they mentioned on your labor certification. So the company will need to submit their tax returns, or if they have more than 100 employees, they submit a letter from the CFO of the company. But they need to have that ability to pay. If you're working there, it's usually very easy to prove ability to pay because they're paying you. So you just submit your pay stubs and W-2s. But if you're not working there, then the company needs to make sure their financials are good enough, strong enough to make sure that your I-140 can get approved. But it definitely can be done even though you're not working there.
I have some serious issues that are going on with some of the companies that I want your opinion on, Emily. I filed the prevailing, my company filed a prevailing wage, and as you know, Emily, it takes 8 months to get the prevailing wage approval. And at the time of recruitment, though, they found marginally eligible person, and now the company says that they can't hire that guy because they are marginally eligible to for the job. You know, typically our company policy is to hire the best and the brightest. But this guy's marginally eligible. He barely meets the minimum requirements of the job, and now the company says that they can't file the PERM. Is that true?
Yes, unfortunately, even though the person is minimally qualified, barely can do the job, that's all that is required for them to be considered qualified and to mean that they cannot proceed to file the labor certification. They have found a qualified, available U.S. worker. They cannot move forward with the process.
And this is going on a lot with major companies, guys, where they're able to find the marginally eligible person, and the companies are telling they can't continue the green card application. So I want everybody to alert to have a plan A, plan B, what to do if the company. Just don't assume that if your company started the prevailing wage, you're going to automatically get a PERM labor certification approval. At one point of time, I would say that, let's say in the peak of 2022, though, the PERM labor certifications were like almost automatically getting approved. But right now, the rate has gone very significantly down, especially with major companies. We are seeing a significant slowdown in the labor filing. They're not filing the labor, or where they're going all the way to the recruitment and they're saying that your labor certification cannot be filed. What are the alternatives? We have made some YouTube videos, but we want you to consult an immigration lawyer to see what are the alternatives available. As we discussed, moving into H-4 EAD is one of the options that you can think into. You can also look into finding company B, even though you're not working for the company. You can also have them file the PERM labor certification. That's a part of what we want to discuss. Anything else, Emily?
Yeah, and also consider there are some green card categories where you can self-sponsor, particularly the EB2 NIW category, which I know for a lot of people, they think, oh, it's just EB2. It's not getting me any improvement over where I already would be. But if your company is not able to make it through the PERM process and you can qualify for NIW, you can sponsor yourself and get your own I-140 approval. Once you have that, you're kind of a free agent at that point. You can move to any company and keep getting those 3-year extensions as long as that I-140 priority date is not current.
Let's look into this aspect, Emily. This I94 validity. This happens a very significant amount of time. Normally, people's passport expires in 10 years, as we know that, and they don't extend it until about 6 months. Now, this is what happens. My H-1B with company A is valid until 2026, March 2026. My passport visa is stamped in the passport until March 2026. My passport, the Indian passport that I got it, expiring in December of 2024. And when I'm entering into United States in June of 2024, they gave me an I-94 only until December of 2024. What are my options?
Yeah, number one, make sure that you always check your online I-94 as soon as you enter so that you know what date they gave you. A lot of people don't realize that their I-94 has been shortened to the passport date until after it expires, and your options are much more limited in that situation. So if you find you're in that situation before the I-94 expires and you have time to get your passport renewed, then as soon as you have that renewed passport, your visa is still valid, you can go out and come back in again, and you'll be given another new I-94 that goes till March 2026, the date that the I-797 and visa actually expire, because your passport is valid beyond that date. So that's usually the easiest option. You also have the option of filing an extension with USCIS if you have caught this problem early before it actually expires. So even though your company already just filed an extension in 2023 that got the approval till 2026, if it's now expiring in December 2024, they can file another extension to get you from December 2024 to December 2027. That does require the company's involvement. They have to file the I-129 again. They have to pay the filing fees again, pay the attorney fee again. So they may not be willing to do that. But if you're in a dependent status like H-4 or L-2 and you're in this situation and you can't travel or don't want to travel, you could file an I-539 to extend your H-4 or L-2 status before it expires. If after it expires, that's where it becomes a difficult situation. You definitely should speak with an immigration attorney because you may be considered to be accruing unlawful presence. We have to look at how long has it been since your I-94 expired. Has it been less than 180 days? You have more options. If it's been more than 180 days, your options may be limited to just requesting a late extension called nunc pro tunc, arguing that the delay in filing was due to extraordinary circumstances beyond your control.
One thing that we request is that there are ways where you can step outside the country. Let's say, for example, in the similar scenario where the I-94 has expired in June of 2024, and now you realize that in September of 2024, you realize that there are some ways where you can step outside the country and come back in, but we definitely request to contact an independent lawyer rather than contacting the company lawyer, because sometimes when you contact the company lawyer says, well, you've been terminated from the job because you're not staying legally in this country. Then you will have no option at that point of time but leave the country. But if you contact an independent lawyer, there might be a solution where you can travel outside the country and can come back in. We have done successfully so many people with no problems at all. So we strongly recommend at that point of time to contact an independent lawyer. Anything else, Emily?
No, I think we can move on to questions.
I want to give some cautions based on some of the legal advisors that I get consultations, and I want to give an advice to some of the people, guys. Don't file H-1Bs. If you lose the job, everybody knows that you have a 60-day grace period. Don't go to companies to file a H-1B where they're not giving you a job and you're paying money to run the payroll. It's fraud. It is felony. It is money laundering to do that activity. Don't involve into it. B2 option is very easy. And people have a misconception that you move to B2, you cannot move back to H-1B. Not true. And B2 is and USCIS is encouraging people to go to B2 and come back into H-1B. We have done for hundreds and hundreds of people, have no issue, none whatsoever at all. One caution we would like to do is, with regards to the EB5 people who have had the EAD in advance parole though, we may want them not to use the EAD in advance parole. I know that in the employment-based, I do keep on, saying that I have used the EAD in advance parole. No, we do not recommend EB5 people because the I-526, if it's not approved yet, it's very similar to I-140 for them. If it's not approved, they should not be using the EAD in advance parole because they'll be losing everything if the I-485 falls down. Now, even the employment-based also, I always tell that once the I-140 is approved though, then it may be safe for them to use it. But once the I-140 is not approved, they should not be using, until I-140 is approved, they should not be using the EAD in advance parole. Now, those people who got the H-1B approval with October 1st start date, in this new quota though, if they get laid off though, before October 1st and their H-1B is approved though, they may have to choose to go to H-1B or STEM extension. There are two different options, which we normally recommend people to do the H-1B. There are some slight risks associated with it. If you lose the job before October 1st, we strongly recommend that you consult an independent immigration lawyer so that we can give options to you. Good with, I just want to give some cautions to people, Emily, that I normally encounter. Good with the questions and answers, Emily.
All right, this question is from Deep D. She says, will my priority date become invalid if I change to H-4 EAD? It's a very good question. And no, it does not. You keep your priority date always, no matter what your status is. The only time you lose your priority date is if the I-140 or labor certification are revoked or invalidated due to fraud or misrepresentation. Simply moving to H-4 EAD, you still get to keep your priority date. No issues there at all.
Mario is asking the question from Facebook that they have filed an I-485 and it's been pending for more than 180 days. And the I-140 has been withdrawn. Is it absolutely needed to file the I-485J or should they wait for RFE? You can wait for the RFE since the I-140 is withdrawn after 180 days that the 485 has been pending. No need to hurry up and file the 485J supplement right now.
Suresti from X says, what are the approval odds for an EB2 NIW? Have you had any successes in NIW lately? It completely depends on the strength of the case and how well it's filed. So that's a really hard question to answer without knowing any background about the person. You can certainly have an assessment done if you're interested in filing in the EB2 to determine how likely your case is to get approved. Our firm has definitely had success with NIW cases every day of the past several weeks, months. There's been some unusual or different RFEs that we're dealing with from time to time, but for the most part, people are still being successful getting NIWs approved.
Kalyan has this interesting question. These questions are coming very frequently right now from Facebook. He's in 5th year of H1B, and the employer is now filing an I-140 application. Should he have to leave the country after 7 years of H1B? Should he consider H1B? First is you should consider H1B. Definitely you should consider H1B. The other thing is that when they're filing an I-140 though, I may recommend to file it in the consular processing. That means you're going to get the green card in your home country. And people ask me a question, oops, what if the priority date becomes current? I've sent the application to India. No, you can still file the 485 application even though you have said to USCIS that you're going to take the green card in India. So because it may save some time for it. Now, if you don't get the H1B and if you max out an L1A, you may want to consider leaving the country for 1 year, and then you can always come back on L1 at a later date. Or in the case where I have advised where people can get the green card directly, if the priority date becomes current, you're in India at that point of time, you can get the green card. So all these things should be on the menu for you. You should consider first H1B, second to do the consular processing, third have an option of leaving the country, outside the country and come back. Now, one option that I don't give it to the people here is leave the company and join a different company. I would not give that option to that people. The reason is that EB1 I-140 is very tough to achieve, and since you are there, your company is cooperating, it's not the right time for you to leave the company. Whether H1B, whether consular processing, or whether leaving the country and working for the same company outside the country and coming back, all options with the same company is better for you.
Rajesh from YouTube says, after my PERM is completed, the attorney filed the I-140 on March 1st in regular processing. 6 months have passed. Still no update from USCIS. What do we do here? That's normal. That's normal processing time for regular processing I-140s based on a PERM. It can take anywhere from 4 to 8 to 10 months to process. Your only real option is to upgrade to premium processing if the employer is cooperative in that. Either you can pay for that or the company can pay for that. There's no restriction on making the company pay for it. So since that's the case, the company should hopefully be willing to upgrade that.
Shruti Bhaskaran has this question. Can my son apply and join the university in the first year of college on H4 and the second year of the college he can convert into F1? The answer is absolutely yes. There is no need for him to immediately. There are a lot of people, because in some states where it's institution if they're an H4 and out of state if they're an F1. So there are a lot of benefits. Sometimes people get it. So you can avail it, but make sure that you apply the F1 before 21 years. Previously, there was like gap kind of like gap thing where you have to be in a B2. Right now, they eradicated that thing, and also they have given a provision of premium processing for F1. So all those provisions are there. So there's no hurry to file an F1. However, though, I want you to get an F1 approved before the 3rd year final semester, though. Not going to the 4th year first semester, because There are some restrictions on OPT if you have not maintained the F1. So that's the reason. But first year not needed, second year not needed, third year is where I tell people to move on to F1.
Shelters says, I've worked with my current employer for 4 years. They're starting my green card process, but the attorney is only using my experience prior to joining the company in order to do the PERM. She says I can't use experience gained during my employer with this company. Yeah, that is correct. That is the general rule, because when the company hired you, you didn't have that experience. So they can't now say they required that experience in order to hire you. Now, there's a workaround. If they're willing to offer you a different position, different from the one that you initially were hired in, and that position is substantially different from, or not comparable to the position you were originally hired in, that could be the reason for the higher experience requirement, and then you can count experience gained with the company. So we do, I'm sure, have a blog post about that, how you can use experience gained with the employer that sponsored you, but that is the general rule if they're sponsoring you for the same position that you were originally hired in 4 years ago.
Ranjan has this question that his daughter has left the country without an advance parole and stuck outside the country. And now, what is special parole? Can we apply through port director? Yeah, there are some situations where that is allowed, especially, for example, if the person is in Syria and now the ISS is attacking, these are Yehudis and they are going to enslave the Yehudis, and this particular person is a Yehudi, yeah, there are some other sort of provisions where those kind of requests can be made. I one time worked with an immigration lawyer to request a special permission, and these kind of things normally we approach the San Francisco Port of Director, where we see that they're a little bit more humanitarian. So if it is extreme cases, there are some situations where they can. But it's just that one of the person has just went outside on advance parole and is unable to come in, though. They are not going to budget. If there is something very emergency, very dangerous for that person to be outside the country, then they may consider that.
Pallavi says from Facebook, will EB2 move? We are, our priority date is 2014. Well, it'll eventually move. I think the better question is when, how fast will it move? And based on all the information that we have from various statistics and the visa bulletin that came out in October, I think it's going to be 2030 before we get back to where the dates were in 2020, which was December 2014. So you probably have another 5 or 6 years to wait.
Ajay, I'm not liking Ajay that much. He says there is a substantial change in the job profile. How can I persuade the attorney to file the 485J supplement requesting EB3? Well, you're not cooperating. I don't know. What do you mean by substantial job change? Are you in the similar profession? Did you change the profession? I don't think so. People moving from Java software to SAP as substantial change. I don't think so. They're all software. Now, if you're moving from Java coffee, now that's a coffee that I drink. I like Java coffee, guys. Now, Java coffee making to Java software, I consider that as a substantial change. So it depends on if you try to argue against your case, though, there's nothing anybody can do. If you keep on telling Java software is not a software, SAP is not a software, I don't know, then we can't help you in that thing. So you are actually defeating your own case, saying that it's a substantial change. So you may want to have an independent, don't tell a lawyer that it's a substantial change. Let the lawyer decide what he wants to. And if you disagree, of course, you are the boss of your case. If you disagree, then you don't have to proceed with it.
Gokul says, is there any way to avoid a gap in current employment when switching from H1B to H4 EAD, especially if we're filing with the primary H1B extension? So we're doing the bundling of the H1B, H4, and H4 EAD. Definitely bundling, file all together, do it in premium processing. And I would look at when the current H-1B is expiring of the spouse that's filing the extension. If it's not expiring for the next 6 months, maybe they're filing the extension super early. I've seen a handful of times where we get the extension of the H-1B approved and the H-4 and H-4 EAD are given a future start date of the start date that's on the H-1B extension approval notice 6 months from now. So to avoid that situation, I file it as an amendment plus extension, requesting a start date now, so that all three are approved and valid on the date that the approval is issued, and they all have the same end date.
My company headquarters location has changed. PERM is in progress. Is there a way I can use my PERM if it gets approved? For sure, you can use it for getting the 1-year H-1B extension. With regards to the I-140 and getting the 3-year extension, I may want to look into closely what the circumstances are and how cooperative the company is. I'm in H-1B with a marriage-based GC in progress, but no advanced role yet. If I travel abroad, will my GC process be voided or needed refiling? Assuming that you're going to you have the H-1B stamping, or you're going to go for the H-1B stamping, which you already have the H-1B approval, your marriage-based green card will not be interrupted, though. You can come back and get the things. Now, this is only for H-1Bs and to some limited extent L1 guys, not to F1s, not to other visas. Don't take it as a broad. This is only for H1s and L1s.
Bautic says, I saw your October visa bulletin video. Seems like EB5 or EB1, A or C is the only option for Indian nationals. Priority date of January 2023. Yeah, I totally agree with that statement. Anything else, EB2 or EB3, it's decades with the 2023 priority date. The only thing that's going to change that is Congress, or if the administration stops counting the family members. Maybe we'll have a chance of those things after the November election, but it's going to going to be dependent on you reaching out to your senator, reaching out to your congressman to get them to push for actual immigration reform during the lame duck session.
Sukshan Arora has this question. The unemployment OPT has been more than 90 days, about 80 days more than 90 days. H-1B consular processing is approved. The question is that, will it be any do I have to answer yes to the question of violation of status? Yes, you have to answer yes to that question. It won't, I mean, we don't see a lot of issues in getting the, we don't see a lot of issues in getting the H-1B approved under the current circumstances, but you have to disclose that information there. Suhas has this question. PERM is approved with company A. I-140 filing is in progress. Received a better offer from company 2. Can I join company 2? Assuming that this is the first I-140 though. If I were you, I will not take the company B offer. I will not take the company B offer. Even if it's more than $100,000 difference between company A and company B. I will not take that thing. Now, if this is a second and subsequent I-140 approval and you don't need this I-140 for any purposes, then I would definitely consider joining company 2.
Chaparala says, me and my wife are on independent H-1Bs with approved I-140s, and I'm considering H-4 EAD as my contract is ending. Do I need to go through her employer? Is it better to file now or once my contract is ended? You don't have to go through her employer. You could file a standalone change of status to H-4 with an H-4 EAD. And that can work if you have time before your contract is ending and to make it through the long processing time of maybe 4 to 8 months for the H-4 and H-4 EAD to be approved. If your contract is ending sooner than that, then you would want to see if her employer is going to be willing to file an amendment plus extension in premium processing along with your H-4 and H-4 EAD, so you can get them all approved within about 3 weeks before your contract ends.
One question coming from Mohan is an interesting question he's coming from. What he's asking is that I am a Canadian citizen now. I'm assuming that he was an Indian citizen, now he's a Canadian citizen. He's asking why, for the green card purposes, they treat me as Indian, which is that you have to wait for the long priority dates and all those things. For non-immigrant visas, for example, for TN visas and E visas, they treat me as Canadian. Can I sue the USCIS on it? No. Here is the thing. The rule for the green cards are different than the rules for the non-immigrant visas. For immigrant visas, it's the country of birth that controls. For the non-immigrant visas, it is the passport. It is just like telling that the rules for the cricket are different than the rules for soccer game. They are completely different. There is a handball, there is LBW for this one, there's no LBW for the soccer. I mean, you can't use that. Why can't they use the LBW there? No, sorry, they don't use that thing. So the rule for soccer is different, the rule for the cricket is different. The same thing for non-immigrant visas, the rule is different. For immigrant visas, the rule is different.
Rakesh says, my company headquarter location changed while my PERM was in progress. Is there any way I can still use the PERM if it gets approved? Really depends on the specific situation. Let's say the company headquarter just moved down the street. Not a problem at all. You can still use the PERM. What if the company headquarters moved from New York to LA? That could be a problem, but it depends on where your work location is. Did that move? Where was the recruitment done? If the company is in New York and moving to LA, but they filed for you for a position in Florida because you're working out of their Florida office and that office isn't moving, you may still be able to proceed with the PERM because the labor certification, the recruitment was done in Florida. So really it depends on the specific situation, but there's a possibility that the PERM may have to be done over again.
Question, can my wife travel on when the EAD extension is pending? H-1B is approved, H-4 is approved, but the EAD extension is pending. Can she travel? Will it cause him? Practically, he's asking when it's going to cause any problem for the EAD extension. The answer is absolutely will not have any problem whatsoever at all for the EAD. And for those people who filed H-1B and H-4 and EAD together, the USCIS is supposed to approve all three of them according to the court lawsuit under which there is an agreement between USCIS and the class action suit, and Stephen Brown from our law firm was the lawyer there, where they're supposed to approve it. So if they don't approve H1 and H4 and EAD together along with the H1B, please contact us and we can contact the USCIS to get it rectified.
Shruti says, if my priority date becomes current after my son turns 21, will he still benefit? It depends partly on how long it took your I-140 to be approved. Let's say that your son turned 21 and then the following month your date became current, but your I-140 was pending for a year before it got approved. We subtract that year from his age. That makes him under 21 for purpose of the Child Status Protection Act, and he still can receive the green card with you, even though on the day of filing his 485, his real age is over 21. But if it took 10 years after he turned 21 for your date to be current, and the I-140 was only pending for 1 year, when you subtract that 1 year, it's not going to be enough to get his age under 21, so he will not benefit in that situation. So we need to know what the child's age was on the first day of the month when your date became current, and how long was your I-140 pending. Subtract that from the age to see if now he qualifies.
Question is what is cross-country chargeability? I'm from India. My wife, let's say, is from Cambodia. Can I use my I-140 to file the 485 for me and my wife? Or does my wife need to have an I-140 approval? No, even you, the Indian person, can have an I-140 approval. You can use your spouse country of birth for the cross-country chargeability. Cross-country chargeability is you're using your spouse country of birth, even though you're not the main applicant, even though she or he is not the main applicant. So the Cambodian, or let's say, for example, Vietnam lady doesn't need to have an I-140 approval. If you have an I-140 approval, if you're married, you can file the 485. You can say that you come under the Vietnam quota, and absolutely no problem with it.
Kieran says, can you please help with any procedure to get an update from the consulate? It's been more than 1.5 years with no update after a 221G, where we submitted all of the relevant documents for an H-1B. I think it's time to sue federal court at this moment. I would contact Stephen Brown in our office, stephen@rnlawgroup.com, to understand what that process is. But we've definitely been able to get things moving in that situation.
A lot of people are asking with regards to the PERM labor certification delay. Stephen Brown is in the pursuit of getting some answers from the Labor Department, though. But there are some ways where if you are looking for a H-1B extension beyond 6 years, though, you can extend the H-1B beyond 6 years. Also, if your spouse needs to an H-4 EAD, though, yes, if you are in the 7th year H-1B extension, your spouse is eligible for H-4 EAD. You don't need to have an I-140 approval to have your spouse. There are exceptions that in the 7th year of H-1B, if you are in, your spouse will be eligible for the EAD approval. Now, let's say, for example, if you file a PERM application in September of 2024, 2023, now we are September of 2024, you can file the H-1B extension beyond 6 years. You don't have to wait for the PERM and I-140 approval. Now, I'm not telling that they should not approve it faster. I'm just telling you some of the ways you can get away with things.
Kumar says, can my wife travel to India with the H-4 extension approved, but not the H-4 EAD? Both were filed with the H-1B in premium processing. Yes, she can. That won't have any impact on the pending EAD application. The H-4 EAD just requires her to be physically present in H-4 status on the time of filing, but she doesn't have to stay in the country while it's in process.
Mark is asking the question. He doesn't got his passport stamped. He came in advance parole, and his passport is not stamped with the entry, though. Will it cause any problem? I don't see that as a problem. As long as the I-94 is reflecting that you entered into the United States, I don't see any problem whatsoever at all for you in the future date.
Pratik 60 says, for laid off folks who submitted the change of status to B2, if the employer is filing the H-1B petition, which option do they choose? Is it a new H-1 or a transfer? Because the change of status is still pending. It is a change of status from B2 back to H-1B. It's not a transfer. The only time they can still file it as a transfer is if you were still within the 60-day grace period and you just happened to file the B2 change of status early. Otherwise, if you're beyond the 60-day grace period, it's no longer a transfer, and instead they have to file it as a change of status. They should do it in premium processing because you won't be able to start work until it actually gets approved.
Sriram Srinivasan, if the green card was issued during the travel and he did not show the green card to enter, or they entered an either advanced parole or H-1B, will that cause any problem at a later date? No, absolutely not. It will not cause any problem. I have had this, seen other people getting done, not a problem. But however, if somebody is trying to come into the United States, I want them to bring the copy of the green card approval. And if you have the H-1B or you have the advanced parole, show them both the things and let them decide what you want to do. Don't hide the information that you got the green card, though. But for those people who did the mistake, have I seen any problem? No, I did not.
Brenda says, my spouse's I-140 priority date is July 2014, but recently changed jobs and the new employer has started the PERM process. I'm on H-1 as well. Will I be able to apply for the H-4 EAD if I move to H-4? Yes, you can use your spouse's old employer's approved I-140 to get the H-4 EAD as long as it was not withdrawn within 180 days of approval.
V is asking this question. The kid is 16 years in India. He's planning to come on 11th grade on H-4. And of course, he will be moving into college. Of course, he can't complete the college by the time he becomes 21. Yeah, you can have the kid go to college on H-4, and before he turns 21, the kid can convert into F-1 visa to stay and work in to stay and go to school in United States.
Bhavneet says, my company's office closed down and they moved all of us to be remote employees. Will it impact my PERM process? Yes, it very likely will. It all depends on the work location that the PERM was filed for. Where were the recruitment steps done? Did the PERM already include the telecommute option? Because if your PERM labor certification and all of the advertisements for recruitment say that this is work in office required in a specific location, but you're actually not working in an office and you can telecommute from anywhere in the US, DOL is going to say you're offering the employee, the foreign worker, a benefit that you're not giving to US workers who applied for that job. There may have been more US workers that would have applied for the job if they had known that this telecommuting was a benefit. So it definitely depends on all the situation with where the recruitment was done and what was included in the advertisements, very likely to impact the PERM process and may have to start over.
Suthi Bhaskaran has this question. His son was a dependent on her husband's H-4, and when the husband passed away, sorry to hear about that, later my son moved into H-4 dependent of, because I'm in the H-4 EAD. Is there anything that can be situation that can benefit? One thing is that if your husband had an I-140 approval, which is earlier than yours, you can take that under certain circumstances, you can take the priority date. That's the only thing that I can think that can benefit your child and also you. With regards to the priority date predictions and the employment-based inventory, please watch the YouTube made by Emily, me, and Stephen Brown last week when the October visa bulletin came in. We did cover the topic a lot. It was just last week's video. You can look into it.
V says, my kid is 16 and in India. Oh, you already got that one.
Any update on the expected spillover numbers from family-based to employment-based? That we will only come to know after October, though. Then until October of 2024, we won't know it. We will know it. There are not many consulate disruptions this year because of the COVID, though. So we may not be expecting good numbers like last year in the fiscal year 2024. We had approximately 25,000 excess family-based green card coming into family. I may not be expecting that much, though. Is it wise to move to H-4 EAD from H-1B? Yeah, you're right. And you can move to H-4 EAD. People ask questions. Let's say, for example, if your priority date becomes current and you're working for the company, can you file the 485? You as the main applicant on H-4 EAD? The answer is yes, you can. Yeah, H-4 EAD has less restrictions than H-1B. You can do multiple jobs. You can flip a burger and make no call. You can sell vegetables if you want to on H-4 EAD. Nobody's going to ask questions on that. So definitely, I prefer H-4 EAD over H-1B, that option. And you can always move back to H-1B at any point of time when the company has a job offer.
Lokesh says, Trump versus Kamala, any impact on immigration laws? Who is in favor for immigration? I'm going to say neither of them are in favor of employment-based immigration. We've seen Trump before. We've seen Kamala before. She's in office now. And we've not really seen any improvements from her, from Biden for employment-based immigration. They've done a lot of things for everybody else, but nothing for employment-based. Now, who would be least worst? Probably Kamala for immigration, because we saw what Trump did. He blocked people from getting visas at the consulate, claimed it was COVID, but there may be other reasons for that. He stopped deferring to prior approvals, which caused so many people to get denials of extensions after they've been in the US for 6, 7, 8 years, getting approvals constantly, and then all of a sudden they get a denial. He's tried to kill the H-4 EAD. It seems like he would plan to do that again. What else did he do? There was talk of stopping the H-1B extension beyond the 6-year limit under AC-21 in some circumstances. Never went anywhere, but there was talk of it. So really nothing positive from the Trump administration when it comes to immigration. Tried changing the prevailing wage calculations. Yeah, so.
I may disagree with you on that simple aspect, Emily, is that I may be a little bit more favorable that I prefer Kamala Harris over Trump. For example, you said that Biden administration didn't do anything good. I would say, simple example of it, they expanded the premium processing. That's one thing they did. They also
That's because Congress made them.
well, let me tell you that they made the 540-day EAD rule for certain H-4 EADs and also for the 485 EADs, which was only 180 days.
They should have just approved them. Why are they
I understand,
taking forever to process it? Just
but
process it. You don't need
some of the things
540
that have been stopped by were been reinstated by Kamala Harris administration, because whenever we call the administration, we call Biden and the Harris administration. Definitely, and you have pointed out 10 different things. Trump administration tried to do it, did it, but Biden administration never went forward, never discussed anything about it. So, could Biden administration have done much better? Absolutely, I agree with you on that. But yeah, no comparison. That's my opinion between Kamala Harris and then compared to the Trump administration. The Kamala name is very, very close to me because that's my grandmother's name. I'm very close to my grandmother. My I-140 is approved in January 2024. Can I file for EAD now? The question is that for your EAD, your priority date has to be correct, which I don't know if you know what that is. But if you don't know what that is, you may have to watch a lot of our videos, because one video won't be enough for you to understand. The priority date has to be current. Yeah, Ashutosh's grandmother's name is also Kamala. That's right.
Shruti says, my job ended in May 2024, applied for the H-4 and H-4 EAD in August last week with my husband's H-1 and premium processing. Will the gap impact my legal status? Yeah, the grace period is only 60 days. And from May to the end of August sure sounds like more than 60 days. So your change of status to H-4 could be denied as being a late filing. So you have to always show that on the day of filing a change of status, you were in status on the day of filing up to that day. With H-1B losing the job, you have the 60-day grace period, but they don't extend it beyond 60 days.
Do I need to go to the H-1B lottery again in 2025? I don't know what that question means. First of all, the 2025 H-1B lottery is over. The next H-1B lottery is considered to be fiscal year 2026, but you can apply it in March of 2025. There are also people asking questions. Emily, what do you think? Will there be a third lottery?
I don't think so. I think they probably selected enough extra this time around to get the number actual filed, but you never know.
Oh, question is with regards to the taxes, Social Security removed from the H-1B holders. So, no, I don't think so. Well, that's a good FICA. What is FICA, Emily? This is for the medical, is right? Medicare. What is FICA taxes? I don't know what FICA.
You'd think I would know that.
Okay, we'll prepare what that is next time. Sorry about that. I know Social Security we are eligible for. We're supposed. Oh, Social Security taxes. Good question though. Do you need to be on a green card holder to benefit later on at a time when you are supposed to receive the benefits? FICA, what I mean is Social Security, Emily.
Oh.
I don't know. That's class action. That's a huge class action. I don't think so. We will be able to win that, but
I mean, that would be, you'd be suing the IRS.
IRS, not the USDIS.
IRS rule that says H-1B holders are considered residents for tax purposes.
But what's his question is, hey, we are not going to receive the, we are not receiving the benefits of it. Why do we have to pay? Is his question. He has a point. He has a point because F1s and STEM extension OPTs, they don't pay Social Security taxes. Why do these have to people? We'll look into it, but I'm not sure if we have the capacity even to just comment on that litigation, though.
Sarvesh says, should we expect consular processing to improve post-election? It's very stressful to get an appointment. I don't know what the consulate's problem is. I mean, how long can you blame COVID? Everybody's gotten back to normal. There's no backlogs anywhere else except for the consulate, DOL, and USCIS, and they just keep blaming COVID for everything. They could open up stateside visa stamping that opens up so many people. They'll have so many open slots for people who aren't in the U.S. if they would just process the people that are already here in the U.S. That is still a plan. I don't see any reason why they won't proceed with the stateside stamping, but when will it happen? That's anybody's guess right now.
I think the best solution for them is to stamp in the state within United States to solve all the problems, Emily. Because at least 50% or at least good number of the stampings will be moved to United States and employment will be generated in United States and things will be resolved. But I don't know why the administration has done some experiments. I don't know why they are not continuing with it though. Ram Naidu has this question. If I move from company A to company B and H-1B has been transferred, will the company A come to know about the transfer? The answer is no, they don't come to know about it. They will not, USCIS will not inform it.
PMD says, can an H-4 with a valid visa travel on the primary's I-797 if the H-1B transfers when the H-4 is in India? Well, if you have the H-4 visa stamp that's valid, that's what you travel on. You don't necessarily need to also provide your H-1B holders I-797. Always good to carry it, but you shouldn't need that. And even if your visa has the old company's name on it, it's still a valid visa. The H-4 does not go away just because the employer changed for the H-1B holders.
Sudhakar Raj is asking this question. He recently moved an L1 visa. My company is initiating the GC process. Can I simultaneously apply green card through national interest waiver? Will that be in conflict with the company's process? Absolutely, you can file NIW and your company can file the green card application, whether they are filing in PERM labor certification or they are filing in EB1C I-140. Either of those things are not going to be any conflict though. Now, if they're filing an EB1C category though, instead of filing NIW, I may just want to pay the extra premium processing, get the I-140 approved in premium processing so that you can avoid the entire NIW. But is it conflict? Is it illegal? Absolutely not. You're not in conflict. You can file both the applications at the same time.
All right, well, I think we're out of time for today. Thank you everyone for joining us. As usual, we'll be back next Tuesday at 5 o'clock Central Time live to answer all of your questions. And